have to fill out disclosures. There's no exemption for them. Okay? What I would do in that circumstance is I would disclose if I were the buyer, I've never lived in this house, here's the disclosures from when I bought the house. I have little personal knowledge. So convey to the buyer that what you're getting from me is unreliable. I don't think I quite said that. But
Yeah.
If a buyer receives the TDS and the handwriting is really poor, and they request that it be typed, and the buyer and the seller doesn't type,
I think the question was if a buyer receives a TDS and the handwriting is very poor, the buyer requested it be typed, can you force the seller to do that? No. But you can force the seller to add clarity so that it's at least legible. I mean, I think the purpose of the code is to make sure that the seller's information gets conveyed to the buyer, but that doesn't necessarily mean you have to force typing. Okay, one more question on this topic, and then I got a lot to talk about, and I don't want to keep you guys here too long. Yeah?
And I noticed on Lynn forms now, DocuSign, the seller can actually check boxes and type on the form.
If the seller can do that, you need to document in your file that you did not do that. Okay, because otherwise the accusation is, and I got to tell you, these claims come up, the incubation period for a claim is generally 3 years after the close of escrow. Okay, I mean, that's normally, I know you guys are not going to sleep because you're going to think about those last 3 years of transactions, right? But what happens is 3 years later, the buyer goes back, or the seller goes, the buyer's attorney goes back and recreates what happened in the file. So they may have no recollection of doing that, and they may say, oh, it's typed, it must have been the agent. So you just need to make sure that you've documented that you did not do that. Okay, how many of you guys are handling non-contingent sales? Anybody? Oh, thank God. Okay, you have one. All right, so I'm going to keep this short since there's only one.
Non-contingent on what?
Writing a non-contingent offer, writing an offer with no contingencies.
Oh, yeah.
Okay, so it is a wave that we are seeing in different parts of the state, and I'm thrilled that it has not come up here, but you guys might see it. I don't like non-contingent sales. I will tell you right now, if your market heats up to the point where you're getting, multiple offers, you may see some smarty pants agent, and I am not encouraging you guys to do this. Okay, I'm not teaching you to do this. Some smart agent who writes an offer that's non-contingent, that gives their buyers no contingencies. Okay, they are very high risk. I've got several, it's the new wave of lawsuits that I'm seeing, where buyers say, well, my agent told me the only way that I was going to get this property is to write it non-contingent. Okay? So be really careful with these. If you are, there's actually a CAR form called Market Conditions Advisory that talks about non-contingent offers. Please don't write a non-contingent offer without clearing it with your manager. They are really, honestly, high risk. If you are a listing agent and you get one of these offers, I strongly recommend that you counter back with a contingency period. Because that way the buyer can go do whatever inspections they want to do, and at least your seller is protected. Yes, question?
My question is, when you say non-contingent, are you saying non-contingent for all contingencies?
For all contingencies.
Okay, but what about non-contingent for appraisal? I mean, we see that all the time.
Did anybody see my blog yesterday? Some did? Okay, that's what my topic was yesterday. And that was, what I am talking about is non-contingent, meaning all contingencies. No loan, no appraisal, no inspection. The inspection is what I'm really worried about. But let me say something about no appraisal contingency, since you brought that up. And I'm glad you did, because actually I think it's so current that I sent out a blog on this yesterday. If you waive the appraisal contingency, I'm going to make this clear. If your buyer waives the appraisal contingency and subsequently can't get a loan because the property didn't appraise, can they get their cancel and get their deposit back? No, they can't. It's now been clarified in the CAR contract. My opinion, that's always been the law. But CAR recently clarified that in the new RPA. So, if you got no appraisal, it's a little bit of a risk because if the buyer can otherwise qualify for a loan, they're potentially jeopardizing their deposit. Okay? But my topic here was really talking about all contingencies because a lot of agents are writing these and they're just ripe for lawsuits. Yeah, Kathy.
Yes, Shannon, and we have seen a lot of those lately, and combine that with the speeding up the escrows to 7 and 10 days. So is there you said to add a contingency period when we're representing the seller. Is there any other protective language we can incorporate to protect all parties, including the broker?
Yeah, I would use the market conditions advisory. I would make sure that the buyer signs off on that. If it's a 7-day escrow non-contingent, put in a 2-day contingency period. At least that way you can say, I gave you the opportunity. Yeah.
So one thing we did and still do in San Francisco as a practice as a listing agent is we provide the pass.
Well, you're dealing with this a lot, huh?
Yeah.
Yeah.
Yeah, I've got 2 coming on there, but we provide a pass, and usually we'll do the clearance in that market because it just heats up. A home inspection.
Yes.
I mean, our pack is like this.
Yes.
It goes out the review. It may encourage them to do, if they're serious, do the home inspection at the time of the broker's door.
Well, here's the problem. I agree with you. In San Francisco, in Oakland, and in Berkeley, the practice is that the sellers do their disclosures up front. They do their home inspection, their pest inspection, all their TDSs. They do the listing agent does their AVID. All the inspections are done up front, and then the buyers, if they're going to do an inspection, they do it before they write the offer.
And you're done.
And then they write the offer. Now, the problem is that I'm now getting lawsuits coming out of that. And the problem is that I've got buyers that are saying, I didn't know I had my own right to do inspections. You didn't properly explain that to me, that I should have been able to do my own inspection. And what they do is they go out and they get a contractor who goes through the house with a fine-tooth comb, and they say, look, if I had had my own person, look at all the things they would have found. Now, I have to tell you, there is a perfect legal world, and there is the business world. And somewhere along the line, we have to find a happy medium, because if you live in the perfect legal world, quite frankly, you're not going to do any transactions, right? And I recognize that. So I try and give you tips that protect you doing what you want to do in the marketplace. So I recognize, and my clients in the Bay Area are writing these offers, they're writing non-contingent offers. I tell the listing agents, to the extent that you can convince the sellers, you should counter it out and do a 2-day inspection and allow that contractor to go in there, okay? I also, to protect you, because I'm not going to be able to do it 100%, because you won't be able to do business, use the market condition advisory and have the buyer sign off on it. You're representing a buyer, go through it with them. You know, go through the different paragraphs and the risks to make sure that you properly documented it.
Well, you have to pick your listing too as a listing agent. Some listings just won't work for that.
No, it won't. It won't. Yeah.
Okay, even if you say, I don't want contingency, you can still reject the contract based on anything you get from the seller. You have a 3-day period.
No, you can't. So I'm glad that you brought that up. First of all, in a non-contingent sale, if a buyer writes a non-contingent offer, they get the TDS up front. The TDS has a 3-day right of rescission, which is what you're referring to.
Don't get it.
But if you get a complete TDS up front, there is no right of rescission. So you don't get a 3-day right. What you're jeopardizing is you're potentially jeopardizing your deposit. You can still cancel.
What about your prelim? What about your other report that you didn't receive that you have the right to?
Yeah, but see, that's the problem. If it's non-contingent, you cannot cancel. Usually you get your prelim up front because there's a pre-escrow that's been opened. So the agents, I'm sure he gets a preliminary title report up front.
I want to get an answer on if there are reports that were not given to the buyer.
Okay, but see, if there are reports that are not given to the buyer in a true non-contingent sale done properly, like the way that he does them, that he was describing it, the buyer has been given everything up front, so they have no right of cancellation. Now, if you waive your inspections, your inspection contingency, and you discover something about the property, what's at issue is your deposit. And if you're the buyer, you can say to the seller, you don't get my deposit because I can argue that I was fraudulently induced into signing this contract. Okay? But the buyer is going to lose something because the seller's not going to give it up entirely. Okay, so we got to move forward because I have a lot to talk about. Okay. Okay, this is a grab bag of miscellaneous issues that our agents have struggled with. Okay, investor properties. I told you at the beginning that 80% of the claims that I see come in from non-disclosure or failure to recommend inspections. Of those, right now, 80% of the cases that we're seeing come out of investor resales. Okay? This is a huge, huge area, and an area that you guys are all involved in. So how many of you have dealt with investor sales? Yeah, okay. So let's talk about how to make these safe. Obviously, we're going to do these sales. I mean, they're a huge part, obviously, a huge part of our business. But there are ways to protect you and to protect your buyer. So here's the biggest problem with these sales. You have a seller who buys a property. Maybe they've never seen the property before. Maybe they've seen it once. They walk through it with their handyman or they walk through it with their contractor and they basically say, okay, replace the carpets, replace the cabinets, put in new appliances, redo the paint, and then we'll put it on the market and list it. And sometimes you guys are involved in this process. Okay, so then the seller leaves. Now the seller is required to fill out the disclosure statement. Do they do that? Yes. Do they have good knowledge of what's going on? Not really. Not really. So on top of everything else, investors, please take this the right way, what is their goal when they buy and sell property?
Make money.
Make money, right? Okay, so does that mean that the new paint and the new carpet and all the improvements they're putting in there, is that going to be Cadillac improvements?
No.
Probably more like Pinto improvements, right? Okay, those of you who've been around for a while, Pinto improvements, right? Okay. Maybe a Pinto worse. Okay. They're probably going to be closer to a Pinto improvement. They are not going to be the best quality in the entire world because the investor is trying to maximize the dollar. Now on top of that, some investors use handymen and not licensed contractors, right? And some of them don't pull permits. Okay, so then you have a buyer that walks in and looks at this property and it's move-in ready. It's beautiful, it's been painted, it's got new carpet, it's got new appliances, it's got new cabinets, and the buyer is really happy with the property. Now the buyer then looks at the disclosures, and the disclosures say there's nothing wrong, right? It's all marked no. Why is it marked no? Because the seller has no knowledge. And the way the TDS reads, it says, are you aware of? The seller says no. Okay, is there a disconnect between the buyer and the seller? Yes, a huge disconnect. So we need to reconnect them and make sure that the seller's disclosures are appropriate and the buyer is doing their investigation, and we will prevent these lawsuits. Okay, so how do we do that? Listing site. When you take a listing, if it's an investor, have them write down what they did to the property. Have them write down how they bought the property. Did they buy it at a foreclosure sale? Did they buy it at a short sale? Have them write this information down. What did they do? What contractor did they use? Did they use a handyman? Did they get permits? Put the name of the contractor down with the phone number and let the buyer go call them. Okay, so I don't think that as sellers they're conveying enough information to the buyer. When you're representing a buyer and an investor, explain to them, you know, this was rehabbed. You should really, you, not us, buyers should go down and pull permits and make sure the permits were obtained. You should encourage the buyer to call the contractor and have the buyers do inspections. I can't tell you how many times buyers walk into these properties and say, oh, it's pristine. What do I need an inspection for? Okay? Have them do their inspections and we'll cut down on these claims.
So I would like, if I can mention mine, nightmare.
No, email me later. Only because I only have about 20 more minutes and I've got a ton of material to get through, okay? All right, title reports. I want to talk a minute about title reports. I don't know if anybody saw the blog from last week. If you guys ever want to be on the blog list, send me an email because I send out little blogs and little snippets. Let me explain to you what a title report is. We use a title report as a disclosure document. It is technically not a disclosure document. We use it that way, but that's not its purpose and that's not what it was designed for. The title company is issuing a title report. It's really an offer of insurance to the buyer. What they're saying is, I will insure your property, but I will not insure the following conditions. And that's what those exceptions are. Where it says 1, 2, 3. What they're saying is, we're not going to insure these items. That's not excluded. So if that easement comes up, an issue with the easement that they're disclosing on there comes up, they're not going to defend the buyer. They're not going to protect title against that. They are only going to protect on things that are not listed. Now, we use it as a disclosure document, and we should use it. In fact, there's even a case out there that says that an agent, there was a transaction that was horrible called Field versus Century 21 that absolutely drives me crazy because everybody misquotes it. But one of the facts of that case is that the house was sitting in the middle of a water district easement, and the water district had the right to open the reservoir and run the water through the house. Okay, and the agent never gave the preliminary title report to the buyer, so the agent had, the buyer had no idea. And in that case, the court actually said agents have to give preliminary title reports to buyers. Okay, so I just want you to understand what a preliminary title report is. So if there is something that's not listed, we can't later say, title company, you didn't disclose that. The title company will ensure subject to their exceptions and subject to their terms and conditions, but they're not necessarily in the job of disclosures. Now, having said that, you need to make sure that the title reports get to your buyer. Make sure that they click on the links and pull things up and look at them. You shouldn't be looking at everything. I don't think it's your job, but I do think that you need to highlight for buyers, hey, there's some easements on this property. If buyers have questions on the preliminary title report, refer them back to the title officer. Title officers are very knowledgeable and they're free, okay? And a lot of times, if you go back to a title officer and you say, will you do a color-coded chart for my client with the easements and stuff, they'll do it for you. It's great information. Now, let me also give you one little tidbit. Some documents on the title report don't have links. For example, an original subdivision map. You should have those documents pulled and sent to your client. Okay, I had a case where on the original subdivision map, by the way, subdivision maps can have easements on them, deed restrictions, etc. It was a low income restriction, deed restriction, and it was buried on the subdivision map. Nobody caught it. So the property was bought and sold, and what it said was that the property can only be sold to a low income person, and it could only be sold for 2/3 of its fair market value. Nobody caught it. So the property was bought and sold for fair market value. All of a sudden, an FBI agent buys it. She goes to resell it, and somebody found the deed restriction. And so the local city, who basically owned the rights to that deed restriction, stepped in and said, no, you can only sell it for 2/3. Think she was happy about that? Yeah, big lawsuit over that one.
Oh, my goodness.
So make sure that you're cognizant of that. Okay.
Wow.
DocuSign, we talked about this issue. Okay, so one concern that's come up with DocuSign, how many of you guys use DocuSign? Yeah, I even use DocuSign.
Digitally.
Okay, so it's probably going to be the same issue whether it's DocuSign or it's a different. So the problem is that what happens if you get signatures back from two signatories, husband and wife, and they're coming back on the same email? And you know one of them is on vacation or unreachable or camping with their son. And you go,
Problem.
now you're put on notice of a red flag. Okay, so I think that there's two ways that you can prevent this. First of all, CAR has a form called the electronic signature verification. It's technically for third parties, but you can use it for your clients and adapt it. Did you get my email on that? Yeah. And you can use this, which basically is a wet signature and verifies the use of DocuSign. The second thing you can do is that if you see a situation where you know Mrs. is out camping with her son and is completely unreachable by phone, and all of a sudden you get two signatures back from Mr.'s email, I would send an email to Mrs. saying, I'm just confirming you signed this document. Okay, I would not do it for every single signature because that's impractical. But if there is a situation that you have a red flag, or let's say they're divorced, and then all of a sudden they both come back, that might be a red flag to you. Or if you know that one doesn't want to do a price reduction and the other one does, and suddenly it all comes back on the same email, I think that I would double check that one. Okay, so on some of this you're going to have to use your common sense. Yes?
If they share an email, they only want one email.
Then I would make sure that you sign the electronic signature verification. Okay? Okay. Photoshopping.
Yeah.
This goes to Keith, wherever he is. Some of the marketing materials that you guys come up with are absolutely amazing. I mean, they're beautiful. I think your industry creates marketing materials like no other industry does. And some of the brochures and the photos and the websites that you guys create are just spectacular. Quite frankly, I looked at some of your websites and copied them because I thought the quality was really beautiful. But one thing that agents are starting to do is Photoshop. Okay, do we Photoshop? Okay.
Yes.
I don't have a problem Photoshopping as long as you are not Photoshopping out defects with the property. And we're now getting fraud claims in against agents from buyers saying the agent Photoshopped the Rottweiler next door out. Okay, because it's not attractive and they didn't want it in the picture and they didn't want anybody to know about it. Okay, think about that. We didn't want anybody to know about that. So we Photoshopped it out. Now maybe every time the buyer saw the property, the Rottweiler was in the garage. So never saw it. So I want you to be careful and think twice. If you are Photoshopping because you're making the house look better, okay, fine. If you are Photoshopping out the electrical wires that go across, or the kid playing the drums in the window next door, something along those lines, don't take it out. And your seller will say to you, I want that taken out, and you need to tell them no. Because I've got these lawsuits right now, and they're big and they're expensive, and I don't like the way that it's going, because the allegation is you intentionally concealed something from me. I know the agent didn't. I know the agent didn't even think about it. What they're thinking about is they're in marketing mode, let me make this property look better, but that's not how it looks after the fact. So I want you to be a little careful there. Okay, releases. No drafting releases. Okay, let me give you an example. I get a call the other day from a manager saying, we need a release. The seller is paying $10,000, and I think it was for roof repairs, if I remember correctly, for roof repairs. And the seller wants to be done with this transaction forever. And then emailed me a copy of an addendum, and with the agent and the manager said, would you take a look at this? And the release said, agent wrote, buyer to indemnify the seller for any potential roof problems in the future. Okay, first of all, that's not a release. And secondly, that's an indemnification agreement, which means that if there is a problem, the buyer will reimburse the seller for any expenses. Okay? That doesn't make any logical sense. Now, the problem with releases is, in this situation, you have a seller that says, I will give you $10,000, but I don't ever want to hear about this roof thing again. Ever, 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 ever. And then we say, okay, fine, we'll draft a release, so you never hear about this again. And we draft up a release, which is a complicated legal document. Now, the reason I say it's complicated, when you look at my releases, they can be a little bit detailed. The reason is because you have to, who's releasing who? Agents, sellers, buyers, inspectors, who's releasing who? What are they releasing? What's the scope of what they're releasing? Are they releasing current issues? Are they releasing future issues? If it's future issues, you have to waive civil code sections. Okay, this goes on and on. You've got to have a covenant not to sue, because you've got to think about that. The point I'm making is that they can be very, very detailed, and there's a lot to think about. But if you draft a release, and we don't get it right, which 90% of the time, because we're not trained in that area, you're not lawyers, we're not going to get them right. The seller gives the $10,000 and thinks they're done with the issue. And then after the close of escrow, the buyer has a new roof leak and comes back to the seller and says, okay, I've got a new problem and you didn't tell me about that. And the seller looks at us and says, wait a minute, I paid $10,000 because I wanted to be done with this issue, and you drafted it and you didn't draft it right. So then we're stuck with the problem, and not only that, but our insurance company looks at us and says, well, I'm insuring you to practice real estate, not practice law. What were you thinking? Okay, and then we've got an uninsured claim. So when it comes to releases, talk to your manager, and we'll figure out the scope of which we need. I mean, I've helped lots of managers draft them on all different levels, really detailed ones to really, really simple ones. Okay. Earnest money deposit disputes. I think we've had at least 5 of these in the last week. Questions about earnest money deposit disputes? Okay, so this seems to be an issue that keeps coming up over and over and over again. So I'm going to tell you what our policy is on this. Earnest money deposits are between the buyer and the seller, not us. It is not our job to go back and get the deposit for the buyer or for the seller. If there is an earnest money deposit dispute, we leave the money in escrow, sign the cancellation of contract, get the property back on the market, and I don't care if you're representing a buyer or a seller. The buyers need to have that property back on the market too, so that you don't have problems with potential damages later on by holding up the property, okay? Because you can compound the problems for the buyers. And the seller needs to get the property back on the market, and if you're the listing agent, you need to get it sold. You leave the deposit in escrow and let the buyers and sellers go fight about it separately. You counsel your buyer and seller, that is a legal dispute. You need lawyers for help with that. If it's less than $10,000, tell them to go to small claims court. But I don't want you telling them you're entitled to your deposit, because that's giving legal advice. And we are not, one important aspect of this is managing our clients' expectations. We need to manage them up front to explain to them that that's a legal dispute that involves their lawyers between them, not us. Because all too many times, they seem to think, based on what we've told them, because we're too helpful, they think we're going to go get their deposit for them, whether it's the buyer or the seller. And then when we say, no, that's not what we do, and that's not part of the scope of the services we provide, and by the way, none of the brokers are going to provide, whether it's Line or Keller Williams or anybody else, they're not going to do this either. But when we say to them, we're not going to go get your deposit back, then they get angry at us. So it's important that we manage their expectations up front so that they understand, hey, if there's and then the minute you get a whiff of this, you need to explain to them, this is a legal dispute between you and the seller or you and the buyer. You need to get your own attorney to handle this because this is a legal dispute and you can't step into it, okay? But we can't write letters for our buyer or seller. Now, another aspect of this, please don't tell a buyer or a seller, oh, you're entitled to your deposit. There was an agent in Oakland who did that. It was a $36,000 deposit. She's representing the seller. She told the seller, you're entitled to the deposit. Based on that advice, the seller did not release the deposit from escrow. The buyer sued. It went to a jury trial. So think about the fees associated with that. The seller lost. The seller had filed a cross-complaint against the agent, and the agent wound up paying the buyer's attorney's fees, the seller's attorney's fees, and their own to the tune of $500,000. Over a $36,000 deposit. Okay? So let's not render opinions on who's entitled. And sometimes, by the way, when you talk to your manager and your manager calls me and asks me about this, I'm going to give you my opinion because I'm opinionated. I may tell you I think that the seller's entitled to the deposit, but I'm only giving you my opinion between us. Don't repeat that to the seller or the buyer. I'm only doing it because I want you to have the knowledge and my thought of where I'm going and what I'm thinking. Okay? But that doesn't mean you should run back to the seller and say, oh, our attorney says. Okay, emails.